Well, we saw what's become known as the Sandton video, a moment between two, turned into a social media sensation as some pedestrians took out their phones to record this intimate moment. It was only a matter of time before Twitter detectives put their hats on and pulled out pictures claiming they were the couple. But now it appears they're in trouble. The man who some claim in the video is the one mentioned in the pictures, has denied these allegations and is gearing up for a legal challenge. But what does the law say about this? Let's speak to someone who knows it all too well, social activist and corporate lawyer, as well as founder of #CountryDuty. I'm sure you all know him. He needs no introduction. Tumi Sole. Tumi, thank you so much for coming through this morning.
Thank you. Thanks for having me.
Let's begin here.
Yeah.
We see the video. Twitter is abuzz.
Yes.
People are sharing it, commenting about it.
Yeah.
What liability do I have as the person that filmed that moment? Because surely they did not ask to be filmed.
This is true, and thanks once again for having me. I think, Twitter as it is, it's about trends, retweets, and likes. But when it comes to such things, people need to really be careful, because you actually find yourself basically defaming someone. What we saw on this, what is now termed the Sandton video, or the infamous Sandton video in this instance, is a situation where someone was sitting and seeing two, assume consenting adults, which they were in my view, engaging in an activity. And, it was then subsequently shared with everyone on Twitter and then went through all the social media. But what is very important that happened and subsequently was the Twitter CSR or FBI, as you would have them, and infamously also known as Black Twitter, did a 1+1, and then all of a sudden you then found that there are these alleged people that they found. And what we know as a matter of fact, and what you've just alluded to now, is the person or the gentleman who said was the one who was engaging in this has denied this. And more importantly, is now taking legal action. So what it effectively means is the person who tweeted, retweeted it, shared it, may well be sued by the person who are alleged to be the people who engaged.
So is this going to go back to the original person? Does it go that far?
Yeah, so in any event, what defamation law requires is there be a publication, it must be unlawful, and it must be, untruthful as well, and it must injure someone's dignity. So what then happened is the secondary victimization occurred when all of a sudden there's a video you could not see on the first one as to who these people are. Then Twitter got on and then they said, no, we found these people. And then the lady actually went onto her Facebook and said, I've just changed my WhatsApp picture and now all of a sudden people are calling me and are saying, this is what it is. But if you then think of the implications over and above the legal issues, these are adults, these are family members, someone, the gentleman has kids and family. He's the managing director. Already, the talk is you are engaging in such activities at the workplace and stuff. And therefore, in my view, and if I were to say this, people who've retweeted it and people who've shared it and commented and said these are the people, they're most likely going to be found wanting in these circumstances.
And let's look at the media then, because the media has a responsibility to report on stories. Certainly. How do we treat such stories?
I think, the media really plays a very important role. I mean, they need to inform, they need to make sure that at the end of the day, any reasonable reader is able to critique, whatever information is there. The danger with either playing to the public gallery, like in this type of video, from a media perspective, is you are also hyping it up. What I observed, in my view, from a Twitter perspective, is the media wasn't as quick to retweet or otherwise, which in my view is great, because they adopted a wait and see. The likelihood is, had they retweeted or spoken about it and stuff, they would have also publicized and they would have been liable to that. But what subsequently we saw is there was then an article where this gentleman came on record and said, it's not me. And this is the other aspect that I spoke about secondary victimization and people who are alleged to have been involved in this activity and when they are not. So I think they were quite responsible. And it's also important to know that, you need to report accurately. You would not say these are the people from the first video. And it is really important to keep the story alive, particularly given the legal implications that would arise. Because at the end of the day, you can't just tweet and defame people. There needs to be consequences. And I think that's what we're most likely going to see.
And some people have argued, some social media users, particularly on Twitter, who have been lambasted for sharing the video. They've said that, no, but if they wanted to not be seen, they should have gone somewhere private.
True.
But was that not a private space?
No, well, in any event, so I think there's two issues here. One from an employment law perspective, and ordinarily in an office space, you don't engage in such activity because there are rules in place, right? So, and if you look at the statement that was issued by this company where this gentleman who's alleged to have been involved in this activity, it says they now know as a matter of fact that this happened elsewhere and the employer took disciplinary measures related to that. Now, it's not for us to critique or make fun of what people do. And the fact that, windows were opened and we all unfortunately became voyeurs of this type of issue, it really doesn't matter. What the consequence were, as I pointed out, suddenly people who were not involved in the activity are suddenly dragged in, and now we know a Lerato who's not involved in this is now seen as that. So it won't really matter. And if the gentleman and the lady who are aggrieved tend to sue by just looking at the retweets and the sharing, and the people who then said, we've now found them as Black Twitter, we did what we could, you're most likely going to get a letter of demand.
And what are they likely to face here in terms of, the damages that they might have to pay?
There's a view, right, in terms of what the court looks at. So it's not a foregone conclusion that you will get 500,000, because that's been the standard in the political arena where you say something. You've seen it in the EFF versus Trevor Manuel case. You've also seen it recently with the Pravin Gordhan case, where the standard has been 500,000. But the court looks at various factors. For example, who are you, your importance, or I would say your dignity and how it's been infringed. If you are managing director, for example, of the company, your shareholders and the impact that would have. So it would vary, and it's always going to be an issue where evidence would have to be led. So it's not a foregone conclusion, in my view, that you'll get 500,000 when you sue. The court needs to hear exactly what the damages were. They would be quantified, and thereafter you'll find that you are entitled to a certain amount.
And to me, there's another issue that we then saw this week, which could also talk about privacy, which could also, get a number of people into trouble.
Correct.
The sick note of former President Jacob Zuma.
Yeah.
The exposure of that sick note also exposed the name of the doctor, and some also then started posting a picture that this is the one and all of that. Does it not violate, client, doctor privileges? Because if it's patient-doctor privilege that you have to, protect, where do we then draw the line as the media?
The Zuma sick note is quite an interesting one, in my view, and there are various factors to consider. For example, the argument, if you look at, and we must just go back to the Manto Chabalala Msimang issue, and I think it was Sunday Times, if I'm not mistaken, where they wanted to publish her health records. And what the media at the time argued, it was, this is in the public interest, and you need to know this, and the public need to know. I hold a different view, and I'm speaking for myself. When it comes to issues of health and the confidentiality related to that, in my view, those things should be handled differently. In the Zuma matter, although he was a former president, the sick note was at a point of contention. I could have then, if I was the presiding officer, for example, called the parties to the side and on record as well and said, we know he's not in attendance. There's this potential medical certificate that is, suspect, for example, and what do we do? Let's then call the doctor who then issued this. The doctor must lead evidence without disclosing the former president's sickness or illness, the fact that the former president was treated on X day, and in their educated view, then he could not attend the trial. But what we would have done, though, is it would still have guaranteed his rights to privacy, to dignity as well. But unfortunately, as it is, we know that the court issued a warrant of arrest and penned it for the next court date, and it basically said this is a fake, sick note, and it's questionable. So it could have been dealt with better, in my view, but the judge who is seized with the matter saw it differently and saw it fit, and the media subsequently, and their role, then reprinted. It was all over social media and basically became a laughing stock. And in my view, it could happen to you, and you could find yourself in this situation. And ultimately, the question is, are we then going to see more of these? Because if you do it with Mr. Zuma, it means you will do it with everyone else. And where do you then draw the line in these type of circumstances?
And to me, in just 30 seconds, we're almost out of time.
Yes.
Then, from what you're telling me, it's a very delicate balance between interesting to the public and in the public interest.
Correct. It is. And it's a very fine line to draw, right? Does interest or public interest mean retweets and the likes or more trend topics? Or does public interest also weighs or takes into account the person's right to privacy and all of those things? So it's not an easy thing. And I think what media houses we are now seeing is they're taking legal advice from the internal departments and saying, how do we report on this? But I'd also urge, Twitter followers, Facebook and stuff, to also think about this. And before they expose themselves to legal action, that before you retweet, if you don't distance yourself, you may well be subjected to that defamation case. So you need to tread carefully.
Tumi, you've just given us a lot to think about as a journalist there. Thank you so much for coming through. That's Tumi Sole there, who is, you all know him, #CountryDuty.